Hi. So in today's class, you are going to learn about few typical terminology which has been used in Indian Succession Act 1925. So there are quite a lot of terms which are not being defined in under the definitions part in this act, right? While you are studying, you are unable to understand few terminology. So today let us discuss few terms which you can easily understand and easily remember that. So before going into that terminology, let me tell you, succession is of two types, which you know. One is the intestate succession and the other is testamentary succession. So what is the difference between these two things, intestate succession and testamentary succession? So basically intestate succession is that a person has not written any will at the time of his death. Whereas the opposite is testamentary succession, where a person has written a will regarding his property and to whom that property should be given in his will, and later on he passed away. So this is called as testamentary succession. So intestate succession, the property will devolve to the persons called as heirs. So these are the people inside the family. They belong to class 1 heirs or class 2 heirs, or they can be agnates or they can be cognates. So whereas while talking about will, which is a testamentary succession, the person who has written the will is called as testator. The person who is writing the will is called as testator, and this will can be written or can be given to any person, let it be the family or out of family. So it's not mandatory that the people only inside the family get the property. Sometimes the person can have love and affection beyond the family for his close members or friends or relatives, or he can donate his property under the will. So he can do anything. And the people who are receiving this will are called as legatee. So remember this term, it is called as legatee. Okay. So now we are going into the definitions part. So you have understood who is a heir. If an intestate succession is happening and the property is devolved and shared, then those people are called as heirs, those who are getting the property which is inside the family. It's actually mentioned under Hindu Succession Act under definition 3 of F. Just refer the section. And legatee, there is no specified definition in any act, either Succession Act or Indian Succession Act. So legatee is the basic terminology which I'm explaining you so that you could understand. So legatee means here the person who is receiving the property and to whom the testator has given the property under testamentary succession. Okay. So these two, I hope you understood now. So now you know who is a testator as well. But the testator is being defined under Indian Succession Act as well, right? If you look into the definitions, so section 2, it doesn't exactly define the testator, but it uses the words, it uses the term testator for section 2 of C, or where it has been using these terms under section 2 of H under will. So these term you have been seen for lot of definitions. So testator is in the sense that a person who is writing a will regarding his property, that person is called as a testator. It has not been defined, but it has been used in other sections. Then who is an executor? This section has been defined under section 2 of C under Indian Succession Act. So testator will be appointing the executor. So on what purpose the executor is being appointed? Here testator, after his death, after his demise, he wanted the executor to execute everything whatever is in his will. So he is giving the power to the executor. So the executor can be a person or he can be any authority or an organization or an institute, where he is assigning the work of his will, to whom it has to be properly given, the work has been assigned to the executor. Who is an administrator? Administrator is defined under section 2 of A of Indian Succession Act. So wherever the executor is not present, that means the testator has not appointed any executor, then any particular authority or the court will appoint the administrator to look into the estate of testator. So such person is called as administrator. So now you know the meaning regarding administrator, executor, testator, heir and legatee. So now let us look into what is a will. So will is defined under section 2 of H in Indian Succession Act. So what does a will state? Basically a will is a legal declaration written by the testator, like how his property has to be devolved or shared between the persons. So will is a legal declaration given by a testator. Okay. Now what exactly is a codicil? A codicil is defined under section 2 of B in Indian Succession Act. So to understand in a basic language, a codicil is nothing but an addition to the will. Suppose the testator has written his instructions in the will to whom the property has to be given, but he has forgotten few more instructions to be added in the legal declaration, the will. So what he does, he doesn't want it to alter the entire will and make a new one. He will just add these separate clauses in an addition in separate document. And this addition is attached along with the will and it has to be read together. So this additional document is called as codicil. So what is a probate of will? A probate of will is mentioned in section 2 of F. So to understand this, it is nothing but a copy of the will which is certified by the court. So the court is certifying, yes, this is a true will document and the property has to be devolved according to this will, and the court has given its seal on that copy of will. Then the document is called as probate of will. Coming to the next term, bequest. This has not been defined in any of the acts. Just to understand, because you see this kind of terminology while looking into the illustrations or to the content in Hindu Succession Act and as well as Indian Succession Act. There is a statement, for example, saying that I bequest 10,000 rupees to B. So simple understanding is I wanted to give 10,000 rupees to B, but bequest in the sense means that I wanted to give this 10,000 rupees to B after my death. That means someone on my behalf should give this 10,000 rupees to B after my death. So this is the meaning of bequest. That means you are giving a statement to be happened, something related to after your death, that you are being giving something to someone after your death. Okay, I hope every term you have understood in an easy way. Let us meet in the next video. Thank you.